All right. Welcome, everyone, again, like I said, to Lead Generation Week, day number 3. We've got a jam-packed day here with some really great sessions, and we're going to be kicking it off with an excellent one here talking about regulations. I know this is an important one or should be an important one for everybody. So I do want to first thank our sponsors for helping us make this event happen, Leadspedia, Drips, and Fluent. Thank you very much. It's been, your support has been tremendous, and we thank everyone that's been a part of the event, and especially our speakers. Before we get started, I do want to mention how to participate. And of course, we want you to participate in all these sessions, especially this one. This is a great one to ask a lot of questions. If you want to ask questions, there's really 2 ways. You can enter it into the app. If you're on your mobile phone or your desktop, you'll see the session Q&A there. You can go ahead and click the button, ask a question, and we'll pass it along to the speakers here. Or you can also see that there's a Q&A icon right underneath the video. If you do that, that will go right into Zoom, and we'll see it there as well. So either way, you can use either of those 2 options, but we do absolutely would love for you to ask questions. So without any further ado, let's go ahead and bring on John Zanarella from Performline. John is the Director of Strategic Partnerships and going to be leading this discussion here, Compliance Full Circle, the lessons lead buyers and generators should know. So John, I'll let you take it away.
Thanks so much, Mike, and thanks for hosting a great week of content. We really appreciate being a part of it, and this is a session that we are excited about. We have a great group of experts here. We know that compliance can sometimes be something that is a challenging thing to tackle. So we're going to really dive into it today and hopefully leave you guys with some practical tips that you can take back and apply to your own businesses. But without further ado, I'd love to introduce our panel, and I'm actually going to pass it to them to give a brief intro and background. So Pooja, why don't we start with you?
Yeah, hey, good morning, folks. My name is Pooja Amin, and I'm corporate counsel at Loan Depot.
Awesome. Jordan?
I'm Jordan Smith. I head up compliance for Even Financial.
Awesome. And Jonathan?
Hi, good morning. My name is Jonathan Pompan, and I am a partner at the law firm of Venable, where I am the co-chair of the Consumer Financial.
Perfect. Cool. And so Mike gave us a good kind of, title and overview of today's presentation. And, despite the size and complexity of the lead gen world, ensuring compliance and consumer protection is top of mind. Over the last few years, especially the CFPB and the FTC and other regulators have really been looking to hold companies responsible, not just for their own activity, but also for that of lead buyers and lead generators. And so again, with the complexity and ever-changing regulatory landscape, companies can be lagging a little bit in their ability to kind of play catch up and follow along. So I'm actually going to start with you, Jordan. For those who don't know, Even Financial is a search, comparison, and recommendation engine for financial services. You guys provide the infrastructure and channel partnerships to connect with consumers for personalized products. And I know that you guys have over 200 plus channel partners. How do you tackle compliance when you have such a large ecosystem of partners?
I do it all by myself. That's me. No, it's a huge task because Even Financial, what we're doing is connecting financial institutions with our channel partners, with the publishers, and to help them convert these consumers into actual customers. And we're in every vertical that you could think of. We're in insurance, we're lending, savings, credit cards, we're soon to be in mortgages. And so we have to have a real process plan in place in order to do that. And from our inception, Even Financial, it has been one of our core attributes, compliance, because we knew that getting into this business was going to be important for every financial institution to work with us, that we had a tried and true compliance program in place that had all the processes, was doing the right things, and was continually doing it, right? And so how do we do that? So we put together a kind of a 4-pronged attack plan. The first part of that is programmatic. technology, right? And that programmatic technology, with the help of actually Performline, helps us put in all the rules, not only regulatory rules, but also brand rules, our own rules that we have. And to watch all of these partners, all of our publishing partners that we are working with, we like to call them supply, and to ensure that they are doing the right things, right? We give them, when we bring them on, we give them rules, we go through education, we tell them what to do, but that of course doesn't always mean that everyone is doing the right thing, or things change. We understand that. So we want to make sure when an APR changes, it gets changed all over across all of our channel partners, so they understand, and our financial institution partners are happy. So that's the first part. The second part is people, and that's the people internal, right? So we make sure that our teams are educated, and by our teams, not only the compliance team, of course, but I'm talking about the teams. We have a partner solutions team that deals with all of our publishers, helps them along, helps them understand the rules, helps them understand what pages need to look like, what needs to be on there. And then the people on the other side that work with our financial institutions to make sure that we are getting what exactly their rules are, besides the regulatory rules, because they have their own brand rules and what they want us to follow. So it's really important for that education and the people to be one and to understand that. The third part is process. So we have a process in place, not only programmatic, but also manual, right? So every single partner that comes in to our into the Even world and becomes a partner goes through a vetting process, right? We look at the partner, we understand what they're doing, we understand what they've done in the past, we understand who they partnered with already, we look at the pages, we understand when there is an implementation, we look at that implementation with us before it goes live to make sure that it's linking out correctly. If it's an API partner, we make sure we have certain rules and certain things like, APR disclosures, income disclosures that all have to be on the page. We make sure those are there, and that's before it goes live. And so that's a process that we have, working with our internal teams and then also working with our partners to make sure they happens. And that's the fourth part of this plan, is partnership. It's really important that we have a partnership, not only with our financial institutions, but even more importantly with our supply publisher partners, that they understand that we are there to help them. And we're trying to get this going in a really compliant way to make sure that they are following all of those rules. And that partnership also has to deal with, and they have to understand that there is an escalation policy, right? So if we find something, we go to them, we tell them to change it, and they immediately change it. And things happen, right? We understand that those things happen. No one's 100% perfect, but they have to understand that is part of the process. So it's a 4-pronged process that we have put in place to help us understand, because we have, like you said, over 200 partners. Can't do it. We can't do it all by ourselves. So we have to have the programmatic, but we can do some of it internal, of making sure that things that we have control over are tried and true and really strong. And so that's really the cohesive part that brings compliance together, brings us together with our partners, and makes our financial institution partners feel a lot more safe and secure.
Thanks for that, Jordan. I feel like a lot of people are probably taking notes on that. I know that when you started at Even, that process may not have been in place. For companies who are listening in right now and maybe they don't have a process, what are some of the things that they should be doing? What internal stakeholders should they be getting in front of to allow them to understand that, look, we need to lead with compliance here. And in order to do that, we need to have a process that's both man and machine. What would you recommend for them?
Well, I mean, the first thing, so I did join Even over a year ago. And the first thing I suggest any compliance person to do when they're going into a new business, a new industry that they've maybe never been into, or that they have, is to understand exactly the product. Go to the products team, learn what the product is doing. Go to your engineering team, learn if you're involved with data, and learn what we're actually taking. Learn all of those things before you actually can develop the policy, right? And then the process, right? You need to have, a lot of companies that, especially our startups, may not have policies in place yet because they're just trying to churn out product. They're trying to turn the engineering team. Everyone's trying to do that. And so when you come in, it's trying to learn what they're doing. Kind of you're in there, and you also need to make sure that they understand that you are there to help them. You are not there to hold them back. One of the things that in my compliance world and how I deal with this is I am not here to hold any product team back, hold any revenue back. I am here to help them and help them gain more revenue, help them gain more product, because there are ways to do things. And we can talk about this later, but in order to help get better revenue out of it, better data, and more comprehensive, transparent stuff that's going on, which will make consumers come in more. And so that's what that would be my main, the gist of what I would tell them is first learn the product, then start with the policy, and then you could go into processes.
Got it. Yeah, we will talk a little bit about that later, kind of compliance as a revenue generator. I think, compliance has had its own rebrand over the years where, it is something that is no longer, adversarial to marketing and sales. It is something that is necessary and can lead and still drive the business outcomes that everyone wants. So glad to hear that you guys are doing that over at Even. Pooja, I'm going to jump over to you next. Everyone knows loanDepot, right? One of the largest non-bank consumer lenders in the U.S. You in particular have an extensive background in TCPA compliance. Before we jumped on, we joked that we could have a week just dedicated to TCPA. But I'm curious, let's hear your thoughts on some of the recent happenings with TCPA, specifically the Supreme Court hearing, oral arguments regarding it.
Yeah, well, as we know, the basis of the appeal of the Supreme Court was pretty nerdy stuff, right? The main issue was First Amendment issues, focusing on free speech, important stuff, but I think things that are near and dear to our heart in this industry right now, and something that the Supreme Court actually didn't take up, was what the definition of an ATD really is. And we know that the ATDS definition is written to include random or sequential number generation. And if the court's going to take that interpretation on, or any other court's going to take that on, then the folks that are calling on specific leads, where we're trying to qualify the item we're trying to sell, then we're not going to trigger the TCPA because we're not randomly or sequentially dialing it. However, as we know, the courts are completely split on this issue. We have the Second Circuit now following the Ninth Circuit with stating that any dialer is essentially an ATDS. Now that includes our power dialing, that includes our purview mode dialing, that includes predictive dialing. And that's unfortunate, but also in the 7th and 11th district, for instance, we have, they're taking the approach where they're following the definition of the statute, which is must include random and sequential number generation. Now, I don't think the court's going to take this up on appeal, but if they do, great for us, right? If they take the definition of what the statute says, that's awesome for us, for folks that are calling based on these specific leads. But unfortunately, I don't think that's going to happen. And so the focus is going to be more on this First Amendment stuff. But that's also important because there's a chance that the entire statute could be struck down on a technical issue. Again, that's just stuff where they're applying, whether they're deciding whether they're applying strict scrutiny, something called strict scrutiny, or not to the statute. And, everyone has their predictions. My focus for our industry is really that ATDS thing. And if the statute gets struck down, I'm sure there'll be some state laws that are going to come out immediately that are going to be very similar to the TCPA.
Thanks for that, Pooja. And I know this is your world, and you've been studying it for a long time. You're kind of widely renowned as an expert on the topic. For maybe some companies who are listening in right now and they don't have someone who's well-versed in TCPA, what are just some recommendations on things that they should be, following and looking at to make sure that their company is protected and adhering to those guidelines?
Well, following Jordan's point, making sure you really understand the processes, for how are you contacting your customers? You really need to get in there and work with the sales folk, work with the folks that are marketing, and really understand how they're operating so you can get in there and kind of provide guidance based off of the statute that's completely, being interpreted in so many different ways. It also helps to have great outside counsel. I would know because I was outside for a bit, so looking at it from in-house, you need that protection in place, and you don't want to have a target on your back. That's extremely important because you have these serial plaintiffs and serial litigators out there who are just going to constantly keep coming, even if they're coming after you or your competitors. If they're in your industry, they already got a hold of you. So you really want to make sure that your processes are buttoned up and you're really getting in there and understanding what folks are trying to do and what they're trying to accomplish so you can better help them.
Thank you for that. I think that's a really important point. It kind of goes across the regulatory landscape. Once you see some enforcement against even a competitor, it really means that you guys are on a list now, and that you need to be buttoned up. And that's a great segue to you, Jonathan. We've been working with Venable for a long time, and we follow your content. It's a great educator for us on what's going on in the legal and compliance space. But in particular, your practice focuses on providing legal advice and regulatory advocacy to a wide variety of clients. In one particular instance, we read some content that you guys put around a case for an education company where they were held liable for the tactics of their lead generators for deceptive marketing and advertising practices. So I'm curious, from your perspective, how has this case impacted the way that companies work with lead generators? And what are some of the things that you're advising clients in this regard?
Sure, John. Well, I think it's important to note that while we're going to talk about the FTC case from last year involving an education company, there were many cases over the history of the FTC in recent years and the CFPB where there's been enforcement involving multiple companies. Sometimes it's the lead generator, sometimes it's the buyer, sometimes it's the buyer and not the lead generator. It'll depend. But very importantly, in the FTC and the consumer protection staff particularly, made a very big point to emphasize that last year in a particular case involving an education company that was very well heeled. It was a major buyer of leads in the lead generation space, as well as also a broadcast advertiser and marketer of its own services, consumer education. The FTC alleged that the company used allegedly leads that were from lead generation that falsely told consumers they were affiliated with the U.S. military, and that they used other unlawful tactics to generate and induce the lead. Now, the company's lead generators also allegedly submitted information through forms and perhaps other means under the guise of providing job or product assistance to the consumer. So in that instance, the FTC alleged and attempted to hold, and through settlement and otherwise, essentially this is where the story lands, the school was held responsible for the activities of the lead generator. Now, we've been talking about that for many years at Lead Generation World and other conferences, but the reality is that one has to not only know the product, to Pooja and Jordan's point, you have to understand what is being sold, so that way you can understand what can be said about the product or service. But you also have to understand what the stream of the lead is from start to finish and what's happening around the generation of that lead. Is it an affiliate marketer? Is it a one-off website? Is it telemarketing? Is it something that is a combination of those services done by multiple companies? Whatever it might be, one has to understand what that stream of commerce is and how, follow the lead. That's what the FTC actually called its workshop in 2016 around lead generation. And that's really a great point. I think that's the most important takeaway from that FTC case, or really a lot of the FTC actions, including even one from late last week. And that is one has to follow the lead from start to finish, understand what's happening there. And at any point, if there's non-compliance, it may be possible to correct, but it may also be very difficult to correct for non-compliance of anybody downstream from a lead buyer. And that's why due diligence on the part of the lead buyer is extremely important. And anybody below the lead buyer, anybody who's involved in the generation of the lead, any of the service providers, really need to be cooperative and helpful in providing that lead buyer enough information, whether it be the TCPA consent or anything else that it travels with the lead, as well as also allowing access to what is said to the consumer to generate the lead.
Got it. And we were talking a little bit earlier this week around just kind of the current environment and regulators and easing certain regulatory burdens with regard to COVID, but it seems like advertising and marketing remain a top focus right now. What do you think is going to come post-COVID with regard to potentially new policy or enforcement?
Well, there's no question. Right now, it's a very challenging time for those in the lead generation space, as well as those that advertise and even provide consumer products and services. In some fields, they're seeing a boom. Certainly, if you sold hand sanitizer today, you were making a lot of sales. But that being said, you're also seeing a lot of companies that are hurting. And as a result of that, they may be changing their business practices for a variety of reasons, going into areas that may be different, maybe COVID specifically related. And the reality is that there's a couple things happening now that will then have perhaps a boomerang effect later. So the first is that the FTC, the CFPB, state attorneys general are extremely active in consumer protection efforts around COVID. So that would mean any get well cures or prevention, as well as also anything related to financial services. Those three areas are really hot areas for enforcement and for scrutiny right now. So if you're involved in those, or if you think you could be involved in those and haven't built out the compliance program around that, it's very important. And that would even include consumer lending. Even if you've been in consumer lending, for decades, the reality is that the nature of the offers and products and how they interrelate to the consumer experience now may be different. The second area, though, that I think is relevant is, and John, to your point, is that there could be a boomerang effect. And that is that in 2008, 2009, 2010, the reality was that a lot of consumers were in distress. There were a lot of companies that, for a variety of reasons, and actors that maybe thought they were entrepreneurial, took advantage of consumers, or at least allegedly took advantage of consumers. And the result of that was that regulators clamped down on products and services that could be offered and the sales channels that could be used. That's why it's extremely important for those that are compliant to stay compliant, and for those organizations that want to protect whatever it is that the business practice or the golden goose, and that could be, for instance, dialing, that could be lead generation overall, self-regulate, and also work to heighten the standards of the industry, because otherwise the entire sector could end up with a black eye. Now, the reality is that there's been a lot of good efforts in that area already. There's already a lot of contractual provisions and privity amongst players in the space that allow for the due diligence that we discussed earlier. There's also audit ability, and there's also a lot of tools to monitor vendors and to be able to take remedial action if necessary, or even to cut back in a particular area. And then I think there's also a lot of ways that you can flow down and also even flow up responsibilities.
Got it. Thank you for that, Jonathan. Any, Jordan or Pooja, anything that you want to add to that? Anything that you think you will be seeing coming out of COVID, or that you guys are doing differently now over the last 3 months?
Well, we all know that advertising is a low-hanging fruit for regulators, and the FTC especially right now is applying strict scrutiny to anything COVID related, PPP, any CARES Act type advertising. And so, using platforms like Performline, in my opinion, are crucial right now, because the need for speed is real. People are moving really fast, and the place to do it is social media, right? And especially during this time, and they're watching, the FTC, they're watching us. And to prevent these costly, fines, we really have to be especially careful right now. So at least on my end, that's what we're working on, is maintaining our compliance policies, but also changing them up where it's appropriate with, CARES Act type lending. You just have to keep up with this stuff, and you have to move as fast as they're moving, because they're watching us, right? And like I said, if it's our competitors getting a target or if it's us, doesn't matter. They're going to come after us hard.
Yeah, I'm near what Pooja just said. It is, I think one of the things that we implemented, we've always had as a rule in part of our policy, is any type of scare tactics, right? It's very, very important in general that our publishers are not out there using some sort of scare tactic in order to get that lead and convert that lead. So then now you add on top of it the COVID and what people have been trying to do, and the FTC every week has something out and has some company that they've been looking at. So it's very important, to have something like Performline, but also to look manually as well as your biggest performers out there, to make sure they're not doing anything. You got to look at revenue, you got to look at things, make sure they're not doing anything and pushing anything in the wrong way. It really has to be a kind of whole company-wide understanding to look at and make sure that you're not only working with the right partners, but you're looking at it on a daily basis and making sure that those things aren't happening.
And just another quick follow-up. Right now we're getting a lot of legitimate claims as well, right? You're going to have folks who need money, they don't have jobs, they don't really have much else to do other than file frivolous claims, whether it be TCPA demands or otherwise. And so you really have to look out for those folks. But every once in a while, you're going to get a real claim, and that's what you're trying to prevent. And to Jordan's point, you have to continue to just keep looking deeper and deeper into your systems to see what's happening, what's going on.
Yeah, absolutely. Jonathan, to your point, talking about consumer finance companies who need to pay attention to some of this as well. When we deployed our COVID-specific rule set to our clients at Performline about 2.5 months ago, we saw a quick adoption by more than half of them who were just, even though they're in the consumer finance space, they knew that they needed to monitor closely anything and any messaging regarding the virus. So that is very helpful. We do have some questions from the app coming in. I think we'll probably cover these towards the end of the conversation, if that's cool with you guys. But Jordan, I wanted to go over to you next. Something you said earlier, you have some interesting thoughts on how the supply side can benefit from being compliant and how monitoring compliance scores can provide higher payouts. Tell us some more about how you're using that at Even.
Yeah, so one of the big things that I have always tried to instill on my compliance teams and the companies that I work with and for is that it's really about a partnership, a compliance partnership with those publishers, supply partners that we have. In some ways, and sometimes I even have right when we, onboard a new partner, after a couple of weeks of them doing what they do, I actually sometimes even have a call with them, and no one likes having a call with compliance, but this is usually a friendly call, right? And usually it ends up me saying, I hope I never have to talk to you again. But it's just to say, hey, I'm here to help you, right? It's a relationship. We are here to make sure that you do the right things in order to be successful. And that's where this whole idea of revenue comes in and scoring. So, in working with Performline, we do score. We score all of our pages. We make sure that those pages are above a certain percentage point. And we look at those. We have found that when you look at compliant pages and compliant partners, we attribute higher revenue to that. And that is because things are more transparent. The consumer comes in, understands what's happening better, understands that it might be a link out, understands that if it's an embed or it's API, what it is. And they actively engage with it, and they actively convert and go on to the financial institution that they're going to go to. And this is part of the relationship that we have with our publishing supply partners. We say to them, listen, we are here to help you. We want you to be successful because, we all are in this together, and therefore we're going to give you some suggestions. We're going to tell you what you need to do in some cases. And even from marketing language all the way up to actual regulatory things that need to be on your page, we're going to tell you, because not only do we want them, but we're telling you that our financial institution partners want them. And if you don't follow them, you're not going to be part of their program. You're not going to be part of our program, and no one's going to make any money, right? And so we take those, so we look at that, we have that partnership, and we take those scores and we see how they're doing. And if there's a lower score, we proactively will go out and talk to them and see what's going on, how it's working, what can we change to see if there's actually a real tried and true violation, or is it something that lowered the score because it, there's a lot of different things within the rules that maybe we have a rule that's just not correct, right? Because we have a rule that says, anything that says penalty, we want, it to ding, and that'll raise the score. But sometimes penalty could be used in other ways, or bonus can be used in other ways that are okay. And so that's what's lowering the score. So you have to look at that and work with your partners to figure those things out. And then from there, move on and have that partnership and have that discussion that we're just trying to help. And we're trying to work together with you to make this a fruitful relationship, and for us all to, we're all in this to make revenue, right? And we want to make sure that though is compliant revenue. And like I said, we have found that those who are more compliant, there's greater revenue, there's greater relationship. It's a longer relationship. We've been with some of our partners for years now because of that, right? And then some partners who just don't get it, they don't get it, and unfortunately they're not partners anymore, right? Because of that. So it's kind of a fine line of understanding your partners, doing the partnership, doing the work, and making sure they understand it's a relationship.
Thanks for that, Jordan. Yeah, we know, working with you guys, the amount of data that you're collecting and how you guys are looking at that data to make more educated decisions. I think a lot of people, maybe don't look at it that way, that if you're working with the right partners, that you will have more revenue on the other side of it and less stress dealing with, remediation and going over terms. So it's an awesome approach. And I think more companies are going to follow your lead there. Pooja, one thing you mentioned earlier was around social media monitoring, and many companies have individual contributors. In your case, it's loan officers. What are some of the challenges that you think are important for companies to know who utilize social to attract leads?
Well, we like to give our loan officers free range, right? They're creative in what they do and they're good at what they do. And we don't want to take that independence away from them. But we also, want, just like we help our partners, as Jordan was saying, they're a part of our team. We want to help them to educate them on what's appropriate. And you can draft up and dream up these policies and send them out, but that's only going to do so much. And I think, with PerformLine, especially, it's helpful for us to just kind of go in there, see what's going on, keep an eye on things like, for instance, even with COVID related stuff, even if we're just looking out for COVID, it can be something completely innocent, or it can be something extremely damaging to the company's brand and even the loan officer. And they may not know they're doing it, so having that relationship with them to help them educate them on marketing materials and how to better utilize their social media platforms, it's important for both them and for us and for our consumers. You want to work with people you trust, and the things you put up on social media are a reflection of you and your company. So you need to continuously monitor that and help them out where it's appropriate, especially with all the regulatory issues that are currently going on. Compliance and legal are the best folks to know about that. We can't expect our officers to know every detail and every nuance surrounding that. That's our job to help them out. And, like I mentioned, PerformLine helps us do that, and in a speedy way as well. Like if I'm going on individually checking each person's social media account, I'm gonna sleep less than I already do.
Yeah, with the number of loan officers you guys have and growing, it would definitely be a tall task. So we appreciate that. And
John, social media, it's also important for folks that do influence advertising. Anytime anybody works with anyone that's recommending or endorsing a product, might not be directly on the payroll, maybe a contractor, maybe that's your business entirely, is being a social influencer on social media. In fact, that may be what we're all doing right now. But setting that aside, the FTC has been extremely active in that area, particularly highlighting the steps that companies should take. And part of that's monitoring, but a lot of it also has to do with making sure that there's appropriate disclosures. So if anybody's working with anyone who's endorsing or recommending a product, and the loan officers inherently do this because it's part of the licensing and the other sort of requirements around being a loan officer. But in non-consumer financial services particularly, there's actually a lot of steps that people in the financial services space have already been doing that influencers need to do in any event, whether they're recommending the next great piece of clothing or a nifty electronic gadget or whatever it might be. And those lead generation activities themselves create a degree of responsibility, not just for the purchaser, but also for the one who's doing the endorsing. And so the FTC's come out with endorsement guides. They've updated them from time to time. They're actually in the process of updating them now. And in particular, when to disclose and what to disclose and how to disclose are all the different areas that one should take into account. And one of the most important things is that the disclosure should be really hard to miss. And I think that's oftentimes where we're seeing investigatory scrutiny, warning letters from the FTC, as well as also in some cases, full-fledged enforcement actions.
Yeah, I think it ties back to what Jordan said, whether it's working with loan officers or affiliate partners, or in this case, influencers, having that open and transparent relationship, focusing on compliant, doing it the right way is likely still going to yield the results that brands are hoping for, with a lot less headaches, and in some cases, some bad publicity to go along with it. So, Jonathan, while I have you, one thing that you mentioned recently in an article about lead generators and buyers was suggesting a contract that buyers should reserve audit rights in their contract. I'm just curious, what exactly should they ask for with audit rights?
Well, audit rights is one of those things, John, that over the years get negotiated heavily from a variety of reasons, including oftentimes buyers don't want to allow anyone they're purchasing a lead from to know what's happening to the lead. It's often been viewed as, well, hey, look, we purchased the lead and it's ours now. But the reality is that in some cases, the seller of the lead needs access to a variety of information, including, frankly, what happened to the lead in order to satisfy its own regulatory requirements, or later on to deal with the outfall from whatever may have happened to the lead. So, audit rights will vary depending on the nature of the counterparties and the activities that everyone's involved in. But it's a big component of being able to ensure compliance. There's several pillars of compliance and multiple lines of defense. Anyone who's probably listening into this session has heard that all before. Well, a big component is auditing compliance. And so if somebody represents and warrants that they are compliant and doing X, Y, and Z, if you don't have the audit rights to be able to then go in and validate that, that's not going to really be very helpful if there was later an investigation. And in particularly for those in the consumer financial services space, there may be regulatory supervision. So it's not a matter of whether or not there's going to be a investigation that you may be one out of 100,000 companies that get a civil investigative demand, but there may be a very high likelihood that at any point in time, and particularly perhaps on an annual basis, you could be reviewed, and you'd want to be able to demonstrate compliance and also good practices with respect to buyers and sellers, depending on where you are in the ecosystem. And, enforcement too, incredibly, things like the Department of Business Oversight and others, exacting a very precise definition or sort of scope that says that their laws for loan brokering or what otherwise would be maybe considered to be just plain old vanilla lead generation trigger licensing requirements. And that would then, but with that comes supervision and examination. And with that then comes scrutiny. It's not to say it's a reason not to go in a particular direction, but those licensing requirements then change the equation from a risk standpoint in terms of what one needs to be able to do for compliance purposes. And I can see Jordan nodding his head. Jordan, you're right in the middle of that mix where you're dealing with licensed people on both sides of the transaction.
Yeah, exactly. I mean, I think it's very important, because we are, number one, we are audited. by the financial institutions that we work with. We're audited because we do have licenses. We have lending licenses, and depending on the states and depending on what's happening, we're in insurance. We have insurance licenses. So each state, we're audited. So it's very real that you have to have a tried and true compliance program. You have to keep on top of things. You have to understand what's going on. You have to then be able to report that out. And people understand that. So yes, that's why I was shaking my head.
Well, we covered a lot of ground in the first portion of this, and I think we have about 10 minutes left. So I do want to jump into some of the Q&A. And the first one is TCPA focused. So Pooja, I'm going to pass this your way. But the question is placing scripts, cookies, or pixels to enable remarketing and retargeting TCPA compliant?
Short answer, yes. The TCPA isn't focused on cookies, etc. But you're going to have some privacy issues there, right? I would definitely recommend you consult a privacy attorney data issue. But so long as you're not using a dialer to make those calls, like the pixels, etc., you're going to be fine from a TCPA perspective. But I would definitely recommend you check out any privacy data issues that may be present there.
Got it. Yeah, I'm sure we could have a whole nother 50 minutes on just privacy related concerns. But thank you for that. And then one other one that came in yesterday as well is, what are your thoughts on TCPA complaints during these challenging times?
Well, as the question implies, they're challenging times. And, I mentioned earlier that folks don't have their jobs, they're looking out for money. So, people are, they're trolling for these complaints. And so you have to be extremely buttoned up and have your processes in line. And, even the folks that aren't trolling, there's more calls being made right now because we're all working from home. We can't go out and market and advertise, et cetera. So everything's being done, whether via the web or through phone calls. So you have to be extremely, extremely careful right now.
Thank you for that. I'm going to leave this one open to the group. Jonathan, maybe this is something that you can help with, but one of the questions is, if we are servicing the leads for a company, are we vulnerable to lead generation practices?
Oh, absolutely. Anyone in the chain is potentially vulnerable for any number of actions that they take themselves or somebody else does. Now, it's possible, depending on how the contractual requirements are set up, that there is contractual risk to one extent or another. But I think it's really important oftentimes for companies, particularly small businesses, to remember that there is a difference between contractual and financial liability and government regulatory liability and risk. Sometimes they're all aligned, sometimes they're not. It may very well be that somebody says that they are compliant, and if they're servicing a lead, there may be reliance upon a contract. But the reality is that the government may not look at that and may look past that to hold all the actors or a combination of the actors responsible. And you can be held responsible for your own acts and practices, as well as oftentimes those of others in the chain up and down. And there's a variety of legal tools that the government uses. Now, sometimes the government overstretches, in my view. But certainly there's plenty of enforcement precedent and cost involved in pushing back on that from a compliance standpoint, one wants to take into account that those before and those after, and those that you may be doing work on behalf of, all have a role to play in order to maintain a compliant ecosystem and compliant counterparty relationship.
Perfect. And then this one, I think, alludes back to something that you had said earlier, and they're just asking if you could please repeat the 3 verticals that are particularly COVID sensitive.
Sure. I highlighted 3 areas of particular scrutiny today related to COVID. That's anything related to a cure or anything related to making an individual well or improving their condition. So those 2 related specifically to COVID and the coronavirus. But then the third, consumer financial services generally, and particularly loans. And many folks in lead generation are not involved in the collection activity stuff, but you could also include collections there too. Those are all part and parcel with offers oftentimes for folks that are in financial distress, or allegations that whatever the product or service, particularly like a small dollar loan, could put somebody in financial distress. And so depending on how those are marketed and the disclosures around them, and particularly if they're tied to COVID, you may be looking at additional scrutiny, and there may be a greater risk for some sort of non-compliant activity. Not to say that it's prohibited. The reality is there are ways to do this, but those are ones where I think the stakes now are certainly higher. The CFPB and the FTC and the states, they're all looking at anything related to COVID as sort of at the top of the list. Right after that's probably consumer financial services, and consumer financial services was always towards the top, and anything particularly related to consumers in financial distress. And that pool of individuals, unfortunately, has grown significantly in recent weeks.
Thanks for that, Jonathan. This is kind of like the lightning round. We have send this now over to you. What would be some red flags or deal breakers when choosing who to partner with?
I'll go first. I think the number one red flag is somebody who will not complete a due diligence questionnaire or will not give it the due that it deserves with respect to answering what are otherwise basic questions. I feel like that has changed considerably in recent years. 10, 12, 13, 14, 15 years ago, we used to see people just crumple up the due diligence questionnaire and throw it away. I think that's changed considerably now. And I think that now, particularly because of a variety of services such as yours and others, where there is more transparency just in day-to-day activity, people have realized that they have to start off the relationship with a degree of transparency. But if that's not the case, I think that would be certainly a red flag.
Cool. Jordan, anything you want to add from your perspective?
I truthfully, and I've come across this too, any partner who thinks that they are perfect and understand everything, because you've talked to partners that say, oh, nothing ever happens to us. We've got it. We understand it. We're good. To me, that's a huge red flag because nothing's perfect. Every partner is going to have issues. Every partner is going to need help. And anyone who says we're good, we're 100% clear of needing any of your help or needing anything like that, that's a red flag to me.
Yeah, absolutely. Cool. So this is an opinion question. Pooj, I'll point this in your direction since you've been on both sides. But do you recommend having an on-staff compliance officer, or can we count on the expertise of compliance attorneys on retainer?
I think it's beneficial to have both. I think a person needs to have you need to have a full-time person in-house to really understand the system, so then they can then in return explain it to outside counsel as well, and then they can provide you with more of the legal background, et cetera, and you can implement their advice. So I've been on both sides. I don't think it can work with just one, in my honest opinion, because outside counsel is going to have a bunch of clients and you're going to be there taking care of it on a daily basis. So my recommendation is have both.
Got it. Jonathan, I see you nodding. You agree?
Absolutely agree. There's no substitute for having boots on the ground, somebody there who is day in and day out attuned to what's happening in the business, understands the product in a way that outside counsel may never, and at the same time can both serve as a translator as well as also, for lack of a better way, a cop on the beat. Outside counsel will often say, we are not the police, we just advise. But somebody who's embedded, and particularly in compliance, not necessarily in legal, is in a capacity to be the honest broker between those who are providing advice and those who are doing implementation. They're also oftentimes involved in monitoring and auditing. So they're involved in really all pillars of compliance. And that can be critical.
Absolutely. Well, we're down to a minute left here, and I want to be conscious of everyone's time. I know you have busy days and Mike has more sessions to run. So on behalf of Performline, thank you so much for participating today. I thought this was awesome. Pooja, Jonathan, Jordan, you guys are doing some great things for your companies, and I think you gave a lot of really good advice to the audience tuning in, as evidenced by the questions that were rolling in throughout the presentation. So thank you guys very much. And I'm going to kick it back to you, Mike.
Thank you.
Thanks, John. Yeah, no, I appreciate you guys all. That was an excellent session. Just a really a lot of helpful information. And then, of course, if people you have questions, if you're watching this later, you can always reach out to any of these individuals via the app as well. So thank you again, and enjoy the rest of your day.